Welcome back to News Conference, talking with the Honorable Dave Jones, Insurance Commissioner for the state of California. When the Affordable Care Act was passed in California, the ideation of it, some have pointed to the fact that there seems to be an inordinate amount of secrecy in the process. That is, we understand that when a contract is put together, a public body will do it in secret because you don't want those who are bidding for that contract to know what the other bidders have done. But even then, once the contract's been awarded, it becomes public. From what I understand, with much regarding the covered California, that process remains secret in perpetuity. That you'll never see the minutes of that meeting and never see the figures or the numbers. What do you think?
There's too much secrecy, and I'm supporting legislation that would reduce the amount of secrecy associated with the exchange. I think that the public should have access to more information. While it's true at the time that a contract's being negotiated, that needs to occur confidentially, so both parties have the ability to put everything on the table and reach a just result. But ongoing secrecy with regard to a whole host of matters, which is currently the case, I think is unwarranted.
There's an effort underway, and we've had the attorneys, consumer attorneys of California here, as well as the California Medical Association, talking about the MICRA law from 1975. There's a effort by the attorneys to put that on the ballot to raise the cap on pain and suffering from $250,000 above. What is your opinion on that?
I don't know that the attorneys have taken a formal position, but there's a consumer group called Consumer Watchdog that has sought to qualify a ballot. They're not actually circulating it yet. They've just submitted for title.
Consumer attorneys in California are very much in favor of it.
I don't know if they've taken a formal position, though. But in any event, yes, there is a ballot measure that's been submitted for title and summary that will then have to be circulated and petition signatures collected before it can be put on the ballot. So they're at the very, very initial stage. What's interesting about this, and I think what a lot of people don't understand, is that these caps on non-economic damages have been in place since 1974 with absolutely no inflation. The opponents to lifting those caps argue that if those caps are lifted, then medical malpractice insurance rates will go through the roof and it'll be difficult for doctors to define medical malpractice insurance. But here's the thing that nobody really talks about, and that is that those caps have not prevented excessive medical malpractice insurance rates. I know this because one of the first things I did as insurance commissioner was look at the medical malpractice insurance rates, and I discovered that the medical malpractice insurers were paying out in claims just a fraction of what they were collecting in premiums from doctors and nurses and other medical providers. So I actually have rate regulatory authority over medical malpractice insurance, not ordinary health insurance, which is really ironic and doesn't make any sense. But what I did was I ordered the top 6 medical malpractice insurers to reduce their rates between 10 and 15%, and I have saved as a result $52 million annually in premiums for doctors and other medical providers. My point is simply this: these MICRA caps, as they're called, which the opponents to the initiative argue are necessary to keep rates down, haven't actually worked to keep rates down. What helps keep rates down is rate regulation, which is an authority I have and have used successfully on behalf of medical providers to try to reject excessive rates.
So medical malpractice has been used by insurance companies as a revenue generation?
Oh, there's no question that the medical malpractice insurers were making more money than they should. And what's really interesting is several of these companies, which are dominant in the market, are owned and operated by doctors themselves. And so doctors are charging other doctors excessive rates. I thought it was outrageous, and that's why I intervened, ordered those companies in. We adjusted their rates. We've saved doctors $52 million. So all of this argument about the necessity of these non-economic damage caps or MICRA to keep rates down misses the fact that excessive rates have been charged even with MICRA, and I think the best way to address that is through robust rate regulation.
Getting back to the Affordable Care Act, Wall Street Journal does a study, and they say they believe for healthy individuals, insurance could go up double, could triple, as a result of the insurance companies being forced now to take people with pre-existing conditions. Do you believe that's possible?
I think that there's no question that we're going to see increased rates. I don't believe it's going to double or triple. And again, for individuals in California who make up to $45,000 as an individual or $95,000 as a family of 4, you're going to be eligible for a premium subsidy that will provide you with an affordable rate. For people above that, though, based on where they live, based on their age, they're going to see a rate increase. And that's why I think we need to change California law and give the insurance commissioner the same authority that I have for these other insurance lines to reject excessive rates. It's simply not acceptable that Anthem Blue Cross can make a 25% profit on the backs of individuals and small businesses, or United Healthcare making over 50% rate of return each year of the last 4 years. And those profits are going to continue into the future, even under the Affordable Care Act, if we don't change California law.
We're talking with Dave Jones, the insurance commissioner. We'll have a few more questions when the news conference returns.